Welcome to today's exploration. We are getting right into a really fascinating document today called Usurpation of Powers and Unlawful Appointments.
Right, which breaks down Articles 239 through 244 of the Revised Penal Code.
Exactly. And the mission here is basically to help you understand the stay-in-your-lane rules of government. You know, what actually happens when the three branches of power, the legislative, executive, and judicial, just start stepping on each other's toes.
It's a great topic because it's essentially an anti-dictatorship toolkit. I mean, separation of powers sounds like something from a dusty textbook, but these articles are the actual teeth of that concept.
Yeah, they turn that abstract political theory into, well, criminal offenses for any official who thinks they can just wear two hats at once.
Exactly.
So let's look at the legislative line first, which is Article 239. This is where executive or judicial officers can actually commit a crime by making general rules that are way beyond their authority.
Or even attempting to repeal an existing law.
Right. Or suspending its execution. You can't just decide a law is inconvenient and block it because you disagree with it.
No, you can't. It prevents that slow motion erosion of checks and balances. It ensures that those who enforce the law aren't also the ones rewriting it on the fly.
And then Article 240 kind of flips it, right?
Right. It restricts judges. They are strictly prohibited from assuming executive powers or obstructing executive officials who are lawfully exercising their functions.
So no running executive departments from the bench.
None at all. But the law is even more protective of the courtroom itself. If we look at Articles 241 and 243.
Oh yeah, 241 is a massive wall. Executive officers absolutely cannot assume judicial powers or obstruct court orders.
And 243 is where it gets incredibly specific and honestly a bit controversial.
Because of the whole suggestions thing.
Yes. It specifically prohibits executive officers from issuing orders or suggestions to judicial authorities regarding cases within the court's exclusive jurisdiction.
Which is wild because in a high-pressure political environment, a suggestion from a powerful superior is basically an order.
That's the challenge, exactly. The law wants to safeguard the independence of the judiciary so that when you walk into a courtroom, the outcome is based on evidence, not a friendly tip from the governor's office.
But proving a suggestion was actually criminal interference has to be incredibly tough.
It's a very high bar to prove. But the mere existence of this rule is meant to act as a deterrent against political pressure.
So it's all about the knowledge of the interference, which actually perfectly transitions us from the courtroom to the HR office. Article 244 covers unlawful appointments.
This is the one that should keep public officials up at night.
Because there's a strict three-part test for this crime, right? First, you have to actually make the appointment or nomination. Second, the person you pick has to be legally unqualified.
And third, the kicker is that the appointing officer has to know they lack those qualifications right at the moment they sign the paper.
That knowledge element is the key.
It really is. It acts as a safety valve. It protects an official who makes a genuine mistake or just relies on bad paperwork.
But it puts the burden of due diligence squarely on the person with the power to hire. It's about the integrity of the office. And here is a crucial distinction for everyone listening, the real aha moment of this document. Simply recommending someone isn't the crime.
Right. You can talk up your completely unqualified cousin all day long.
Trying to get him a government gig.
Exactly. That might be annoying, but the legal hammer only falls on the final decision maker who signs that appointment knowing the cousin doesn't fit the requirement.
The law targets the person holding the pen, not the person whispering in their ear.
Because the decision maker is the final gatekeeper of public trust. These laws collectively make sure authority isn't just about what an official can do, but knowing exactly where their power ends.
They really are the guardrails, keeping the government from absorbing itself.
Absolutely.
Well, before we wrap up this exploration, here is a final provocative thought for you to consider. If the law distinguishes so clearly between an order and a mere suggestion made to a judge, where is the line between professional communication and criminal interference in a high-pressure government environment?
That is the big question.
It really is. In a world of backroom meetings and off-the-record lunches, how much of this job snatching is happening right in front of us under the guise of simple communication? It's definitely something to mull over the next time you see officials discussing an active investigation.
Hey everyone, let's talk about something really important. The legal rules that act like traffic cops for the government. They're designed to make sure everyone in a position of power, well, stays in their lane. But what happens when they don't?
I mean, it's a huge question, isn't it?
We hear about checks and balances all the time, but what does that actually look like on the ground? What happens when an official decides to just ignore the boundaries and step way outside of their job description? The easiest way to picture all of this is like a massive highway. Our government has different branches, and each one has its own specific lane to drive in. The law paints these bright, clear lines to keep them separate, because crossing over isn't just a simple mistake. It can actually be a crime. Okay, so to understand the rules of the road, you've got to know the lanes, right? Government power is split into three main branches. You've got the legislative, who makes the laws, the executive, who enforces them, and the judicial, who interprets them. The laws we're digging into today are the guardrails that keep these three from swerving into each other's territory. So let's start with the first big no-no, messing with the power to make laws. That job belongs exclusively to the legislative branch, and Article 239 of the Revised Penal Code basically puts up a giant do not enter sign for everybody else. So who exactly is this do not enter sign for? Well, the law is super specific. This isn't a crime for just anyone off the street. It can only be committed by an officer from the executive branch, think a president or a cabinet member, or a judicial officer, like a judge. And the law spells out exactly what's off limits. An official from another branch can't just start making up their own general rules. They can't try to get rid of a law passed by the legislature. And they definitely can't just decide to hit pause on a law's enforcement. All of that's the legislature's job, and theirs alone. All right, let's switch gears and move to the next lane. This is all about protecting the executive branch, the folks who actually carry out and enforce the laws. Article 240 is there to make sure no one else can just jump in and start doing their job for them. And this is where it gets really, really specific. For this particular crime, the only person who can be held responsible for overstepping into executive duties is a judge. It kind of makes you think, why so specific? Well, it's probably because a judge's power is so unique. If they start interfering with how laws are enforced, it totally short-circuits the very system of justice they're supposed to protect. There's a real case, People versus Hilvanato, that shows you just how laser-focused this law is. In that case, a town councilor tried to perform an executive function, but the court said, nope, you can't be charged under Article 240. And the reason was simple. That law is written for judges and only for judges. Sure, the councilor might be liable under a different law, but this one has a very narrow target. So what does this look like in the real world? It pretty much boils down to two things. A judge can't just take on an executive power, like, say, trying to personally direct a police investigation. And second, they can't get in the way of executive officials who are just trying to do their jobs lawfully. Now for our third and final lane, the judiciary. This is all about protecting the power of the courts to interpret the law and settle conflicts. Article 241 makes sure that nobody from the outside can just put on a robe, grab a gavel, and pretend to be a judge. See, now the tables have turned. This crime is aimed squarely at an officer of the executive branch who decides to step into the judicial ring. A police chief or a mayor, for instance, can't just hold their own little trial and hand down a verdict. That's not their job. And the forbidden actions are pretty straightforward. First, an executive officer can't just start acting like a court. And just as critical, they can't become a roadblock to a legitimate court order. When a judge makes a final decision, they have to respect it. So we've covered the big three lane violations, but the law also gets into the nitty-gritty of other specific ways power can be abused. These are the kinds of actions that can really undermine the whole system from the inside out. Okay, check out Article 242. Picture this. An official is handling some kind of case, but someone formally challenges their authority to even be involved. If that official is then legally ordered to hit pause while the issue gets sorted out, they have to stop. If they ignore that and just plow ahead anyway, well, that act itself is a crime. Now, this next one, Article 243, really gets to the heart of why all these rules even exist. It makes it illegal for an executive officer to try to give an order, or even a subtle suggestion, to a judge about how to handle a case. The whole point is to protect a cornerstone of democracy, a judiciary that's completely independent and free from outside pressure. And finally, we've got unlawful appointments. Now, this isn't just about accidentally appointing someone who turns out to be unqualified. The key thing here, the part that makes it a crime, is what the official is thinking. They have to know the person they're appointing doesn't meet the legal requirements for the job. It's all about intent. Okay, so we've looked at all these very specific articles. Let's zoom out for a second and ask the big question. Why does any of this really matter?
Why is staying in your designated government lane so incredibly important? Because at the end of the day, these aren't just some boring technical rules for government employees. They are the fundamental guardrails that prevent any one person or any one branch of government from getting too powerful. This is the system of checks and balances that protects fairness, order, and ultimately our freedom. And that brings us to one last thought to leave you with. We've gone through the legal lines that those in power are not supposed to cross. But knowing the rules is only half the battle, right? It makes you wonder, what's our role as citizens in making sure these lines are actually respected and in holding people accountable when they do step over them? Something to think about.
Imagine for a second that you work in, I don't know, a fairly standard corporate office. Nothing too fancy.
A regular 9 to 5.
A regular 9 to 5 setup, exactly. You've got your accounting department, right?
Yeah.
They're handling the money, counting the beans, making sure everyone gets paid.
Sure.
You've got your HR team. They're dealing with the people, the disputes, the hiring process.
All the interpersonal stuff.
Then you have the sales crew bringing in business and the operations folks who, keep the lights on. It's a machine. And like any machine, it works because every part, every cog knows its place.
Right. It's a system built on specialized roles. Efficiency really depends on everybody, staying in their assigned lane.
Exactly. Now, picture this. You walk in on a Tuesday morning, you're holding your coffee, just trying to start the day, but you look over towards the conference room, and the head of accounting is suddenly running around the building trying to fire people.
Oh.
He didn't talk to HR. He didn't check the employee handbook. He just decided he didn't like the color of someone's tie, or maybe the way they type, so he's just shouting, "You're fired," at random staff members.
That is an immediate lawsuit waiting to happen. I mean, that is wrongful termination central right there.
And it gets worse. You back away slowly into the break room to hide from the chaos, and you find the CEO, the person who's supposed to be setting the grand strategic vision for the whole company.
The big picture guy.
The big picture guy. And he's lying on his back under the sink with a pipe wrench. He's decided the plumbing is his personal problem today. He's ignoring the actual maintenance staff. He is actively flooding the kitchen floor.
Oh my goodness.
And he's screaming at the janitor about water pressure.
That sounds like a complete and utter nightmare. A recipe for total organizational collapse. The person responsible for strategy is tinkering with pipes, and the numbers guy is just destroying the workforce.
Exactly. It's chaos. It's wildly inefficient. And in a corporate setting, that kind of behavior, well, it probably gets you fired, or at least put on a very serious performance improvement plan.
At the very least.
But here's the thing. When we zoom out and we apply this exact same scenario to the government, it's not just about a flooded kitchen or a messy lawsuit.
No. When it happens in government, the stakes they're infinitely higher. It's not just inefficiency you're talking about. It's about the potential breakdown of democracy itself.
That is what we are looking at today. We are talking about staying in your lane, but specifically in the context of government power. We're doing a deep dive into the legal consequences, the crimes that happen when people holding power decide to stop doing their job and start doing someone else's.
We're talking about the crimes of usurpation and unlawful appointments.
Exactly.
And, the word usurpation, it sounds a bit dry on the surface. It's a heavy, almost archaic word. You expect to hear it in a fantasy novel about someone stealing a throne.
Right, like a medieval drama.
Precisely. But what we're really talking about here is the legal framework that stops a dictatorship from forming. This is the criminal law version of checks and balances.
And we have a stack of documents here to guide us. Specifically, we're working from a legal syllabus. It's labeled Syllabus 10, Book Tick 2, Title 7, Chapter 6, Section 3. It covers Articles 239 all the way through 244 of the Revised Penal Code.
And what we're going to find in there is a very specific, very strict list of thou shalt nots for public officials. And these aren't just, guidelines or suggestions. These are felonies.
So our mission today is to decode some of this complex legal jargon. We want to turn these article numbers 239, 240, 241 into something real, something you can picture. We want to understand what actually happens when a judge tries to be a mayor, or when a mayor tries to be a judge.
Or when someone knowingly hires their unqualified cousin for a job they have no business doing.
Right.
You could almost call it the drama of power struggles, just distilled into criminal law.
I love that phrasing, the drama of power struggles. Because if you really look at history, that's what so much of it is, right? Just a series of people trying to grab power they don't legally have.
Absolutely.
So let's unpack this. We all hear about the separation of powers in, like, high school civics class. It's a nice theory. But how does the law actually enforce it? How do we stop the CEO from trying to fix the plumbing?
Well, before we can even get to the punishments, we have to establish the lanes. If we're going to talk about staying in your lane, you have to know where the lines on the road are painted.
Okay.
And the highway of government has three main lanes. First, you've got the legislative branch.
These are the lawmakers. They write the rules.
They write the rules. They're supposed to represent the will of the people. So they draft the statutes, they debate the policy, and ultimately they decide what's legal and what isn't.
Lane one.
Lane one. Then, moving over, you have the executive branch.
The enforcers. The doers.
Exactly. They take the laws that the legislature wrote and they apply them. They put them into action. They run the police, the military, the administrative agencies, the Department of Foreign Affairs. They make things happen.
Got it.
And finally, lane three, you have the judicial branch.
The referees.
That is the perfect word for it. They're the referees. They interpret the laws. They decide if the executive branch actually followed the rules, and they decide what the legislative branch actually meant when they wrote the rules in the first place.
Okay, that seems simple enough. So if we use, say, a restaurant analogy, the legislative branch writes the recipe. The executive branch cooks the meal.
Yes.
And the judicial branch writes the Yelp review to tell you if you followed the recipe correctly.
That is a surprisingly decent analogy.
Yes.
The legislative writes the recipe, the law. The executive is in the kitchen cooking, and enforcing and executing. And the judiciary, they're the food critic or maybe the health inspector. They check the work against the standard that was set by the recipe. The problem starts when the cook starts trying to rewrite the recipe in the middle of dinner service.
Or when the food critic tries to jump into the kitchen and start chopping onions.
Precisely. And that is where this concept of usurpation comes in. The syllabus we're looking at calls these crimes usurpation of powers.
This sounds so aggressive.
Think of it like criminal trespassing. If you're an official in one branch and you step into the territory of another branch to exercise their specific power, you are trespassing. You are usurping authority that was never given to you.
And unlike regular trespassing, where you might just get a small fine.
In government, this is a much bigger deal. This strikes right at the heart of the Constitution.
So let's start with the first one in our syllabus, Article 239, Usurpation of Legislative Powers.
This is a big one. And this article, it specifically targets executive or judicial officers.
Okay, so let's be super clear on who the potential bad guys are in this scenario. We're talking about the president, a governor, a mayor, a police chief.
Those are all executives.
Right. Or on the other side, a judge, a justice, a magistrate.
Correct. Those are the potential offenders. If a regular citizen, you or me, tries to write a law, nobody really cares because it has no weight. I can write the law of my living room on a piece of paper right now, but it doesn't mean anything.
It has no force.
But when an executive or a judge does it, they have the appearance of authority, they have the seal of office, the official letterhead, and the crime is committed if they do one of three very specific things.
Okay, let's walk through them one by one. The first one listed here in the syllabus is making general rules or regulations beyond the scope of his authority.
Making general rules. It sounds so bureaucratic, doesn't it? But this is incredibly dangerous.
Why? What does that really look like in practice?
It looks like an attempt to legislate from the wrong chair. Let's create a scenario. Let's say you're a mayor and executive officer. Your job is to run the city and enforce the ordinances that were passed by the city council.
The city council being the legislative body.
Exactly. They are the ones elected by the people to create the city's rules. The mayor is the general manager. The council is the board of directors that sets the policy.
I'm with you.
Now, let's say this mayor, he really hates, let's say he hates red hats.
Okay, red hats.
He just thinks they're tacky. He thinks they ruin the aesthetic of the town square. So he goes to the city council and he says, I want you to pass a law banning red hats on Sundays.
A bit specific, but okay.
The council debates it, they listen to their constituents, they vote, and they say, no, Mr. Mayor, people like their red hats. It's a matter of freedom of expression. We are not banning them.
So democracy in action. The legislature has spoken, and the answer is no.
Exactly. But the mayor gets frustrated. He thinks he knows better than the council. He thinks the town needs saving from these awful hats. So he goes back to his office, sits at his big mahogany desk, and he issues an executive order.
Ah.
And this order says, starting today, wearing red hats on Sunday is illegal and punishable by a fine of 500 pesos.
He just wrote a law. He completely bypassed the council.
He has stepped out of the executive lane and swerved violently into the legislative lane. That is the very definition of usurpation of legislative powers. He is making a general rule that applies to the public, which is far beyond his authority. He is enforcing his personal will as if it were a statute.
And that makes perfect sense. I mean, if we let executives just make up laws whenever they want, we basically have a monarchy.
We do.
The whole point of a republic is that the person enforcing the law isn't the same person who wrote it.
Precisely. It separates the will from the force. If the same person writes the law and enforces the law, you have tyranny. There is no check. There's no balance.
Okay, so that's the first prohibited act. What's the second one under Article 239?
The second one is even more audacious. It's attempting to repeal a law.
Repealing a law, as in just deciding a law doesn't exist anymore. Like, poof, it's gone.
Yes, exactly that. Imagine a judge is hearing a case. There's a law on the books that clearly applies to the situation. Maybe a law about contract timelines or property boundaries.
Oh.
The judge thinks the law is stupid. Maybe he thinks it's outdated or unfair in this specific case. Instead of just interpreting it or saying it doesn't apply in this particular scenario due to the facts, the judge issues a decree. He writes in his decision, "This law is hereby wiped from the books. It is void. It is gone."
Wait, can a judge even do that? I thought they could strike things down as unconstitutional. Isn't that their job?
That is the nuance, and it's a vital one. A Supreme Court, acting as a collective body, can declare a law unconstitutional. That is the power of judicial review, and it's a cornerstone of the system. But a lower court judge or an executive officer like a governor cannot simply repeal a law because they disagree with the policy behind it. If a police chief holds a press conference and announces, you know what, the speed limit law is hereby repealed, drive as fast as you want, that is usurpation. He is attempting to destroy the work of the legislature.
I'm noticing a very specific word in the syllabus note here. It doesn't just say repealing, it says attempting to repeal.
That is a crucial detail, yes. The crime is perfected even if they just attempt it.
So it doesn't matter if they succeed.
They don't have to succeed. Because, frankly, under the law, an executive or a single judge can't legally repeal a law anyway. Their order would be void from the second they issue it. A mayor declaring murder is legal now doesn't actually make murder legal.
Right.
But the mere act of trying to do so, of issuing that order, that constitutes the crime.
So you can't use the defense, well, nobody listened to me, so no harm, no foul.
No. The attempt itself is seen as an attack on the integrity of the legislative branch. It's a declaration that your office is superior to the lawmakers, and that undermines the public's faith in the entire system.
Okay, so making rules, trying to repeal laws. What's the third act listed here?
The third act is suspending the execution of a law.
Suspending it. So not getting rid of it, just putting it on pause.
Exactly. And this is historically very significant. In the old days, kings would often use this power. Parliament or some other body would pass a law the king didn't like. And the king wouldn't try to repeal it. That would be too aggressive and might start a revolution. He would just suspend it. He'd say, you know, we're simply not going to be enforcing that right now. We'll put a pause on it.
It's like a pocket veto on steroids.
Yeah.
It's a passive-aggressive tyranny.
It's a great way to put it. And under Article 239, if an executive or judicial officer suspends the execution of a law, they are committing a crime. If the law is on the books, the executive must enforce it. You don't get to pick and choose which laws you feel like enforcing today.
You can't just say, I'm not going to enforce theft laws today because it's raining and I don't want my officers to get wet.
Precisely. Or, we're not going to enforce environmental regulations this month because a big corporation offered me a donation. That suspension of the law's execution is a criminal act.
This really highlights just how rigid these lanes are meant to be. It's not a suggestion. It's a criminal offense to mess with the legislature's work after it's done.
It has to be. It protects the voice of the people. The legislature is, in theory, the most direct representative of the public will. They are elected to make these choices.
Right.
If an appointed judge or a single executive can just silence the legislature by suspending their laws, they are effectively silencing the people who voted for those laws in the first place.
Okay, so that's Article 239. Don't pretend to be Congress. Got it.
In a nutshell, yes.
Now, let's flip the script. What if you're a judge and you decide you want to play executive for a day? That brings us to Article 240.
Article 240. Usurpation of executive functions. Now, look very closely at who the offender is here. The syllabus is extremely specific about who commits this particular crime.
The syllabus says, offender is a judge. just a judge.
In the context of the source material we're looking at, it highlights the judge as the primary offender for this specific article. But here's where it gets really interesting from a legal perspective. There is a specific exclusion mentioned in the notes.
Ah, I see that. It mentions a case, People versus Hilvano.
Yes.
And it says, legislative officers are not liable for usurpation of executive functions.
This is a classic law school trap question. It's a nuance that trips people up all the time.
So walk us through it. Why on earth would a legislative officer get a pass for doing executive work? That seems totally unfair.
It does on the surface. But let's go back to our lanes. Imagine you have a city councilor, a legislative officer, and this councilor starts doing executive things. Maybe he starts personally directing the police force on where to patrol, or he goes down to the public works department and starts managing the city budget directly, signing checks, hiring contractors.
Okay, so he is clearly usurping executive functions. He's doing the mayor's job. So you charge him under Article 240, right?
Wrong. And that's exactly what the People versus Hilvano case tells us. Because Article 240 was written specifically to target the judiciary interfering with the executive, a counselor, a legislator cannot be charged under this specific article.
So the law was designed to keep judges and executives separate, not legislators and executives.
For this particular article, yes, the law is that precise.
So the counselor gets away with it. That seems like a massive loophole. He could just run wild and do whatever he wants.
No. The law always finds a way. The note here points out that the counselor would be liable under Article 177.
A different law.
A different crime entirely. It's a broader usurpation of authority law with different elements to prove. But for the specific crime of usurpation of executive functions under Article 240, the offender has to be a judge.
Okay, that is a vital technical distinction. If a prosecutor charges the counselor under 240, the case gets thrown out and the lawyer looks incompetent. You have to use 177.
Precisely.
So, sticking with the judge, what does it actually look like for a judge to usurp the executive?
The syllabus lists two main acts. First, assuming power pertaining to the executive authorities. And second, obstructing the executive authorities in the lawful exercise of their functions.
Give me a real-world picture of assuming power. What would that be?
Okay. Executive power is about administration, management, and enforcement. Let's say a judge is overseeing a case regarding a business permit. The dispute is whether the permit was denied legally. The judge rules on the case. That's his job.
Right.
But then the judge decides, you know what? I don't trust the city's licensing office to handle this correctly going forward. So the judge, on his own initiative, goes down to City Hall, walks into the permit office, sits in the mayor's chair, grabs the official stamp, and starts signing and issuing business permits himself.
He is literally doing the administrative work of the executive branch.
Exactly. He is administering the government. That is not his job. His job is to resolve disputes about the permits, not to issue the permits. He has left the bench and entered the bureaucracy.
And what about the second part? Obstruction. This feels more aggressive, more confrontational.
It is. Imagine the police are conducting a lawful raid. They have a valid search warrant signed by a competent court. Everything is by the book. They are about to enter a warehouse looking for, say, smuggled goods.
Okay.
Suddenly, a different judge, not the one who signed the warrant, shows up at the scene.
The judge shows up at the crime scene. That feels like something out of a TV drama.
It does. And let's say he knows the owner of the warehouse. Maybe they play golf together. He physically blocks the police from entering. Or he stands in the doorway and issues a baseless verbal order right there on the spot, commanding them to stop their lawful duty.
So he's not in his courtroom. He's not reviewing a motion to quash the warrant.
No. He is just using the weight and title of his office as a judge to obstruct the executive branch from doing its job in the field.
So it's all about the judiciary stepping out of the courtroom and trying to micromanage things on the street or in the administrative offices.
Yes, the judiciary is designed to be, for the most part, passive. They wait for cases to come to them. They are reactive. The executive is active. They go out and enforce. They administer. When the judiciary tries to become active and run the show on the ground, that's Article 240.
It's fascinating how specific this is. It really builds a wall around the judge's role. It says, you stay on the bench. You do not get to play sheriff.
It has to. I mean, if judges could also enforce the laws, they would be judge, jury, and executioner. That is the very definition of a lack of due process. There would be no one to appeal to because the person arresting you is the same person who is sentencing you.
Literally. Okay, let's keep it. We've had the executive acting like the legislature. That was Article 239.
Right.
We've had the judge acting like the executive, Article 240. Now, surely we have the executive acting like a judge.
Which brings us logically to Article 241, usurpation of judicial functions.
And the offender here is an officer of the executive branch.
Correct. So your mayors, governors, police chiefs, cabinet secretaries, and so on.
And again, we see two prohibited acts. One, assuming judicial powers. Two, obstructing the execution of any order or decision rendered by any judge within his jurisdiction, assuming judicial powers. I feel like this is the plot of a lot of old Western movies. You know, the sheriff decides someone is guilty and just deals with it himself.
That's the classic, most blatant example. If a mayor or a police chief decides to hold a trial in their office, determines that someone is guilty of a crime, and then imposes a sentence, that is usurpation of judicial functions. Only a court has the power to determine criminal liability.
Even if the mayor's totally convinced the guy did it.
Even if he has video evidence, he cannot adjudicate. He cannot say, I sentence you to 30 days in jail, or I order you to pay a fine of 10,000 pesos to this other person.
It seems so obvious when you put it that way, but I can imagine in smaller towns or in really high-pressure situations, that line gets blurry. The mayor might say, look, I'm settling this dispute between you two right now, and suddenly he's acting like a small claims court judge.
Exactly. Arbitrating disputes with the force of law is a judicial function. An executive can mediate, sure, they can try to help people find a compromise, but they can't issue a binding judgment that strips someone of their property or their liberty. That power belongs to the courts alone.
But the second part of this, the obstruction part, feels like it could be more common and maybe even more dangerous. Obstructing the execution of an order.
This is absolutely critical for the rule of law to function. Think about the nature of the judiciary. They have no army, they have no police force of their own, they don't have guns.
All they have is the pen.
They only have the pen. They write judgments on paper, and they rely entirely on the executive branch to carry out those orders.
That's kind of a scary thought, actually. If the executive can just ignore the judge, then the judge is completely powerless.
Precisely. So let's say a court rules that a prisoner must be released because their constitutional rights were violated during their trial. The judge signs the release order. It's a valid, final legal document. But the warden of the prison, an executive officer, looks at the paper and says, no, I think this guy is dangerous. I don't care what the judge says. I'm not letting him go.
That's obstruction.
That is a crime under Article 241. And it's so vital because if the warden can just say no, the court order is just a piece of paper. It becomes worthless. Article 241 is what ensures that the piece of paper has teeth. It says to the executive, you might have the guns and the prison keys, but you must listen to the judge.
It's a check on brute force. It subordinates physical power to legal judgment.
It is. Without Article 241, the judiciary is just a fancy debate club. This law is what compels the guys with the guns to listen to the guys with the books. And in a civilized society, that is the only thing that keeps the courts relevant and powerful.
So we've covered the big three usurpation swamps, but the syllabus has a few more articles that seem a bit more nuanced. They deal with the friction between the branches. Let's look at Article 242, disobeying requests for disqualification. That sounds very procedural.
It sounds procedural, but it's really about fairness. It's about due process at its core.
The offender here is a public officer. That's a broad category.
Yes, this applies to anyone who has some kind of adjudicatory power. It could be a judge, certainly, but it could also be a hearing officer in an administrative agency, or a labor arbiter, or someone on a professional licensing board.
And the scenario is what? Proceeding is pending before them. But someone raises a question about that officer's jurisdiction.
Right. Let's say you're a hearing officer in a government agency. I'm a citizen and I have a case in front of you. I file a formal motion saying, hey, you are not allowed to hear this case. Maybe I argue you're biased because you own stock in the company we're suing. Or maybe the law says a totally different department is supposed to handle this specific issue.
So I'm challenging your right to be the referee in my game. I'm throwing a penalty flag on the play before the game is even finished.
Exactly. Now, usually there is a higher authority that needs to decide that question. Is this officer actually disqualified or not? And figuring that out takes time.
And while that question is still pending, while it's being decided,
you, the officer, have been lawfully required to refrain from continuing. You've basically been told, pause the tape. Don't do anything else in this case until we figure out if you're even allowed to be here.
And the crime is just pressing play anyway.
Yes. If the offender ignores that requirement and continues the proceeding before the jurisdiction question is settled, they are liable under Article 242.
Why is that a crime, though? Why isn't it just a procedural error? Why do we potentially send people to jail for this?
Because if you plow ahead, you might render a decision that is completely void and has to be redone from scratch. You waste everyone's time, money, and resources. But more importantly, you might trample on the rights of the person who challenged you in the first place. It's a form of institutional arrogance, ignoring the check on your own authority.
It's like you're saying, I don't care if I'm allowed to be here, I'm just going to do it anyway.
Precisely. It's like playing a game while the referee is in the booth reviewing the footage to see if the game should even be happening.
And you score a touchdown while everyone else is standing around waiting for the call.
It cheats the process, completely undermines the legitimacy of whatever outcome you arrive at.
Okay, that clarifies 242. Now, Article 243 seems spicy. Orders or request by executive officers to judicial authority.
This is what I like to call the phone call crime.
The phone call.
You see it in movies all the time. The powerful governor calls the judge in the middle of the night and says, hey, listen, we really need a conviction on this one. It's an election year. Don't you dare let this guy walk.
And that isn't just unethical, that's actually illegal.
Strictly illegal under Article 243. The offender is specifically an executive officer. The act is addressing any order or even a suggestion to any judicial authority regarding a case that's within their exclusive jurisdiction.
That word suggestion really sticks out to me there. An order is obvious, do this. But a suggestion, that sets the bar really low for what constitutes a criminal act.
It does, and for a very good reason. The syllabus explicitly states the purpose here. To maintain the independence of the judiciary.
Because even a hint of a suggestion from a powerful figure carries an implicit weight.
Exactly. If the president of the country suggests something to a lower court judge, is it really just a friendly suggestion? Or is it a veiled threat? Is it nice career you have there? It would be a real shame if something happened to it. The law wants to prevent even the appearance of that kind of pressure.
It protects the judge too, right? So if the governor calls, the judge can immediately say, stop right there. You are committing a crime by even bringing this up with me. I'm hanging up the phone now.
Yes. It gives the judiciary a shield. It creates a very clear, bright line. I cannot discuss this with you, and you cannot discuss this with me. It preserves the sanctity of the judicial decision-making process.
I noticed there's an exemption here too. It says, legislative or judicial officers not liable under Art 243.
Yes, and this is interesting. A Supreme Court justice can certainly tell a lower court judge what to do. That's just how the judicial hierarchy works. That's the appeals process. So judicial officers are exempt because they have to talk to each other about cases.
And what about a senator, a legislator?
A senator expressing an opinion on a court case is generally seen as part of public discourse or their oversight function. They have protections like speech and debate clauses. They can stand on the Senate floor and shout, "This court case is a travesty, the judge is completely wrong." That's political speech.
But the executive can't.
But the executive branch, the one that controls the police, the military, the budget, the appointments, is strictly forbidden from whispering in the judge's ear.
It's trying to create a soundproof wall between the police and the administration on one side and the courts on the other.
It tries to. We know that in reality, these lines can get blurred, social circles overlap, but the statute is there as a clear warning. Don't do it. If you get caught pressuring a judge, you are a criminal.
So we've covered all this usurpation of powers. People doing jobs they aren't supposed to do. People pressuring others. Now let's move to the final section of our deep dive. Article 244, Unlawful Appointments.
This is the one that probably affects the most people in a direct, tangible way. The previous articles are about high-level constitutional clashes. This is about how people get government jobs. This is the daily grind of bureaucracy.
The bad HR clause.
That's exactly what it is.
So Article 244. The offender is a public officer. The act is nominating or appointing a person to public office.
But here is the kicker. The person they appoint lacks the legal qualification for that office.
Okay, so if the law says the city engineer needs to be a licensed civil engineer with 5 years of experience,
and you, the mayor, appoint your buddy who is a college dropout with a degree in philosophy.
that's a problem.
That is the factual basis for the crime. But we have to look deeper at the elements here. There are two massive nuances that make this fascinating, and they honestly explain a lot about how politics actually works.
Okay, the first one I see in the notes is the huge distinction between appointing and recommending.
Yes. This is the so-called loophole you mentioned earlier. The syllabus says it clearly. Offense committed by nominating or appointing. Recommending unqualified recommendee is not a crime.
Wait. Let's role play this for a second to see if I understand the absurdity here. If I'm the mayor and I have the power to appoint, and I appoint the philosophy major to be the city engineer, I could go to jail.
Potentially, yes. You violated Article 244. You misused your official appointing power. You are the one who signed the paper.
But what if I'm the mayor's chief of staff, a very powerful person, maybe the guy pulling all the strings behind the scenes, and I write a glowing letter saying, I highly recommend this brilliant philosophy major for the city engineer position, and I pressure the mayor, and the mayor listens to me, I'm completely off the hook.
You, the recommender, are not liable under Article 244.
How?
Because you didn't make the appointment, you just gave bad advice. The law puts the responsibility squarely on the person with the signature.
That feels oddly convenient for the people with influence, but no official signature authority. It allows for a lot of influence peddling without any of the risk.
Well, think about where the responsibility has to lie. The buck stops with the person who holds the appointing power. The law expects the appointing authority to be the final gatekeeper to do their due diligence. If the mayor listens to a terrible recommendation, that's ultimately on the mayor, not the person who gave the recommendation. The law assumes the appointer is a responsible adult who can say no.
So you can be the suggestion guy for unqualified people all day long, as long as you aren't the one signing the actual appointment contract.
Legally speaking, under this article, yes. Morally or ethically, that's a completely different story. But Article 244 is strict. It punishes the specific legal act of nominating or appointing. It assumes the appointer has agency and should know better.
Okay, that leads right into the second nuance, the mental element, the guilty mind.
Mens rea, yes. The syllabus says, offender knows that his nominee or appointee lacks the qualifications at the time he made the nomination or appointment.
So it has to be intentional. It has to be knowing.
It can't just be an honest mistake. If the philosophy major forged a diploma, created a fake license number, and completely tricked you, the mayor, and you appointed him thinking he was a licensed engineer, you are not liable.
Because you didn't know. You were a victim of fraud yourself.
Correct. But if you knew he wasn't qualified and you appointed him anyway, maybe because he's your nephew or he donated a lot of money to your campaign or you just owe him a favor, then you are on the hook.
How would a prosecutor prove knowledge? That seems like it would be hard. I didn't know.
Yeah.
It seems like a very easy defense to raise.
That's always the hard part in court for crimes that require intent. But usually it comes down to the blatantly obvious nature of the lack of qualification. If the requirement for a job is must be a lawyer, and you appoint someone who clearly isn't, and you've known them socially for 20 years, it's very hard to argue you didn't know they weren't a lawyer.
Or if their resume is completely blank in the education section.
Exactly. Or if, say, your HR department sent you a formal memo explicitly stating this candidate is not qualified, and you went ahead and appointed them anyway, that memo becomes Exhibit A for the prosecution.
It's a law designed to prevent the government from becoming a pure patronage system where qualifications don't matter at all.
It tries to ensure that competence is the absolute baseline. You can play politics, sure, you can pick your friends over your enemies for a position, but that friend still has to be legally qualified for the job. You can hire a friendly, qualified engineer, but you can't hire a friendly non-engineer for an engineering job.
It's still so interesting that we have criminal laws for this. Usually you'd think, oh, the appointment is invalid, just fire the guy. But no, the person who did the hiring actually committed a crime.
It reflects how serious public office is supposed to be. Public office is a public trust. Treating it like a personal gift shop where you hand out jobs to your friends is a fundamental violation of that trust. It damages the public service. It makes the government incompetent and ineffective.
Okay, so let's recap the traffic rules of government we've learned today. We have covered a lot of ground here.
All right, let's boil it down to the essentials. Rule number 1, executives do not write laws. Judges do not write laws. And if you try to repeal or suspend a law made by the legislature, you are crossing a bright red line. That's Article 239.
Rule 2, judges, you need to stay in the courtroom. Don't try to run the police department or the city administration. You are not the mayor. Stay on the bench. That's Article 240.
Rule 3, executives do not play judge. You cannot hold trials in your office. And for the love of democracy, when a judge issues a valid order like releasing a prisoner or stopping a project, you obey it. You do not get to veto the court. That is Article 241.
Rule 4, If someone legitimately challenges your right to be the referee in a game, you stop the game until that's settled. Don't be arrogant and just plow ahead. That's Article 242.
Rule 5. Executives, keep your distance from the judges. Don't call them, don't text them, don't suggest how a case should go. That is tampering, plain and simple. That's Article 243.
And finally, Rule 6. Don't hire people who aren't legally qualified, especially if you know they aren't qualified. But feel free to recommend them, apparently, if you want to be that guy. And that is Article 244.
A pretty comprehensive guide to keeping your government job and staying out of prison.
So what does this all mean for us? Why should the listener care about these very specific articles? I mean, most of us aren't mayors or judges. We're just trying to get through the week.
Because these laws are the invisible architecture of our freedom. We often take it completely for granted that the police won't just lock us up without a trial, or that the mayor won't just declare a new law on a whim because he had a bad day.
We just assume the system works. We assume the plumbing is fixed by plumbers and the accounting is done by accountants.
Right. But the system only works because these boundaries exist and are, for the most part, enforced. When you see news stories about constitutional crises or executive overreach or dictatorial tendencies, it usually boils down to one of these articles being violated in spirit or in letter. It's someone refusing to stay in their lane. It's someone thinking they are above the structure.
It's the difference between a government of laws and a government of men.
That is exactly what it is. If the lanes on the highway disappear, it's just whoever has the biggest truck driving wherever they want. And that is incredibly dangerous for everyone else on the road.
I want to circle back to that loophole in Article 244 before we go. That recommendation loophole.
It really sticks with you, doesn't it?
It does. Recommending an unqualified person is not a crime. It feels like the law is winking at us. Like it knows how the world really works but can't do anything about it.
It is a provocative thought to leave on.
Think about the real world for a second. In many organizations, and definitely in politics, the recommendation is the thing that matters most. If the big boss recommends someone, the person who is technically doing the appointing often feels they have to do it.
The implicit pressure.
Yeah.
The recommendation that is actually an order in disguise.
Right. So my question is, does the law draw the line in the wrong place? Does allowing public officers to formally recommend unqualified people without consequence actually undermine the integrity of the system, even if it's not technically criminal?
That's a great question for the listener to think about. Perhaps the law assumes that the appointing authority should be strong enough and have enough integrity to say no. It puts the entire burden on the gatekeeper. But human nature is a lot harder to legislate. It's hard to say no to a powerful friend or a political patron.
Something to mull over the next time you ask for a reference letter. Or, maybe more importantly, the next time you see a suspicious appointment in the news and you find yourself wondering, who recommended that guy?
Always follow the recommendation trail.
Exactly. Well, that's our deep dive for today. We hope you have a better understanding of the trespassing rules of government.
Stay safe, read the fine print, and watch out for any flooding in the kitchen.
And please, whatever you do, stay in your lane. Unless, of course, you use your turn signal. Thanks for joining us on the deep dive.
Welcome to The Debate. Today, we aren't just reading a rule book. We are looking at the operating system of the state. We are cracking open the revised penal code, specifically Title VII, Chapter 6.
Right, Section 3.
Exactly. And to the untrained eye, Articles 239 through 244, they look like a dry list of do's and don'ts for public officials. But if you look closer, you see the architectural blueprint of government authority. We are talking about the crimes of usurpation of powers and unlawful appointments.
And frankly, blueprint is it's a very generous term. When I read these articles, I don't see a blueprint. I see a map that is missing half the roads. These articles, which supposedly stop officials from abusing their power, are full of oddly specific loopholes. They tell us exactly who the law trusts, and more inevitably, who the law effectively immunizes.
I think immunizes is a strong word to start with, but it sets the stage perfectly. The central question we are debating today is quite simple. Does the rigid categorization of these crimes, specifically separating which branch of government can commit which crime, does that create a robust system of checks and balances? I represent the position that it does. I believe these boxes you dislike, that are necessary firewalls.
And I take the view that those firewalls are made of Swiss cheese.
My argument is that by explicitly excluding certain officials from specific liabilities, like the fact that legislators are virtually untouchable in Articles 240 and 243, the law fails to address the messy reality of how political power is actually wielded. We are looking at a code that creates dangerous pockets of immunity.
Well, let's test that theory. I want to start with the concept of the firewall. When I look at Articles 239, 240, and 241, I see a perfect triangulation. The code is trying to prevent the collapse of democracy by keeping the three branches distinct. Look at Article 239, usurpation of legislative powers. The elements here are incredibly specific. The offender absolutely must be an executive or judicial officer.
Right, so the president, a mayor, a judge.
Exactly. And look at what they are forbidden from doing. They cannot make general rules or regulations beyond the scope of their authority. They cannot attempt to repeal a law. They cannot suspend the execution of a law. Now pause and think about what that actually means. This isn't just about someone overstepping. This is the definition of anti-tyranny.
You're framing it as a shield against dictatorship.
Because it is. History is littered with executives, kings, generals, presidents, who decide that a law is inconvenient, so they simply suspend it. Or they decide the legislature is too slow, so they issue a decree that functions as a law. Article 239 is the lock that snaps shut on that impulse. It prevents the executive or the judiciary from becoming a legislative body. It protects the legislature's monopoly on making laws. It's not a loophole, it's a barricade against the most dangerous form of power grab.
I don't deny that preventing a dictatorship is a good thing, obviously, but you are focusing on the gravity of the crime, and I am focusing on the mechanism of the law. You see order, I see asymmetry. You mentioned Article 239, but let's look at its mirror image, Article 240, usurpation of executive functions.
Which prohibits assuming powers pertaining to the executive authorities.
Sure, but look at the element of the offender. In Article 239, the offender can be executive or judicial, broad. But in Article 240, the offender must be a judge. That's it. The text explicitly narrows the field. It effectively says that the only person capable of specifically usurping executive functions in this context is a member of the judiciary.
There is a logic to that, though. Who is in the position to paralyze the executive? It's the courts. A judge is the only one who can issue an injunction or a temporary restraining order that stops the police or the mayor in their tracks. That power, the power to say stop under the color of law, is unique to the judiciary. That's why the law targets them, specifically in Article 240.
It sounds compelling in a vacuum, but we don't live in a vacuum. We live in a world with ambitious politicians. Have you considered the case of People versus Hilvano? It's cited right there in the source material. In that case, you had a municipal councilor, a legislative officer, who was essentially acting as the mayor. He wasn't just making laws, he was executing them. He was usurping executive power. By any definition of the English language, he was usurping executive functions. But, because he was a legislator, and Article 240 says the offender must be a judge, he couldn't be charged under Article 240. The Supreme Court effectively threw up its hands and said, well, the law doesn't apply to you. They had to charge him under Article 177, which is a generic usurpation charge.
But he was charged. That's the point you are missing. The system worked. Article 177 covers usurpation of authority generally. The fact that the specific Article 240 didn't apply doesn't mean the counselor walked free. It just means we classify his crime differently. Legal clarity requires we don't stretch the definition of judge to include counselor. If we start pretending words mean things they don't, that is judicial overreach in itself.
You are glossing over the difference in stigma and severity. I just don't buy that it's a mere classification issue. Article 240 is a crime against the separation of powers. It is a high crime. Article 177 is effectively a crime of impersonation. It's the difference between charging someone with treason and charging them with trespassing.
That is a very dramatic comparison.
But it holds up. By forcing the system to charge the counselor under 177, you are treating a constitutional violation like a mere case of pretending to be an officer. It obscures the nature of the threat. The code essentially gives legislators a pass on the high crime version of usurpation. It says if a judge does it, it's a threat to the republic. If a legislator does it, he's just playing dress up.
I see why you think that, but let me give you a different perspective.
I think it prevents the prosecutor from overcharging. It demands precision. If you are a judge, you are held to a higher standard regarding executive interference because you have the gavel. If you are a counselor, you're just a noisy politician overstepping. The law recognizes that distinction in power. A counselor pretending to be mayor is an annoyance. A judge enjoining the mayor is a constitutional crisis.
Or it recognizes that legislators wrote the law and decided not to criminalize themselves.
That is a cynical take, but let's move to where I think the code is strongest and where your legislative immunity argument hits a hard wall. Article 243. Orders or suggestions by executive officers to any judicial authority.
The Judicial Independence Clause.
This is the shield of the courts. The elements are crystal clear. The offender is an executive officer. They address an order or suggestion to a judicial authority regarding a case within their exclusive jurisdiction. The purpose, as explicitly stated in the source material, is to maintain the independence of the judiciary. This is vital. The executive controls the police, the army, the Department of Justice. If they start suggesting how a judge should rule, the rule of law is dead. Article 243 criminalizes that mere suggestion.
Hold on. Mere suggestion. You're saying if the president calls a judge and says, I think you should convict this guy, that's a crime.
Under Article 243, yes.
Absolutely. Because when the man who controls the prisons gives a suggestion to a judge, it's not a suggestion, it's a threat. It implies consequences. It implies do this or else.
I agree with that interpretation. My problem isn't with punishing the president. My problem is, once again, who we aren't punishing. The source material explicitly states legislative or judicial officers not liable under Article 243.
Here we go.
Think about the reality of politics. Who confirms judges? The legislature. Who controls the budget of the judiciary? The legislature. If a powerful senator who sits on the Appointments Commission calls a lower court judge and suggests a ruling implying that their promotion to the Supreme Court depends on it, that is just as coercive as a police chief making a threat. Maybe even more so, because it threatens their career, not their physical safety.
I see where you're going, but I maintain the nature of the threat is fundamentally different. The executive threat is immediate and physical. Incarceration, enforcement, the state's monopoly on violence. A senator's suggestion is political pressure. Is it unethical? Yes. Should it be grounds for impeachment? Probably. But is it a crime in the revised penal code? The law says no, and I think that's correct. We must be careful not to criminalize political discourse.
Political discourse? Extorting a judge for a ruling isn't discourse. That's racketeering.
But where do you draw the line? If a senator gives a speech on the floor saying the court should rule a certain way, is that a crime? If we expand Article 243 to include legislators, we risk gagging the legislature. But if a president sends a memo to a judge saying, rule this way, that is an order from a superior in the hierarchy of state enforcement. That distinction matters. The executive has the gun, the legislature only has the purse.
To the judge losing their independence, the result is the exact same. The judgment is tainted. The code fails to protect the judiciary from the branch that holds the purse strings. It creates a blind spot where political coercion is legal, but executive coercion is criminal. It assumes the only bully in the playground is the one with the badge, completely ignoring the one with the checkbook.
It focuses on the most immediate threat. The law can't solve every ethical lapse in a democracy. It focuses on the breaches that look like tyranny. But let's shift gears to the mechanics of how these officers are stopped in the moment. We've talked about the high-level separation of powers, but Article 242, disobeying request for disqualification, is fascinating because it happens in the trenches.
Fascinating is one word for it. Procedural trap might be another.
Well, let's explain what it actually does first. It details a specific process. A question of jurisdiction is raised before a proper authority. The officer is lawfully required to refrain from continuing, yet they continue. This prevents a rogue officer from railroading a proceeding when their authority is in doubt. It ensures that when someone shouts, "You don't have the power to do this," the officer has to pause.
Right. Like, wait a minute, you're a traffic cop. Why are you investigating a homicide? That kind of thing.
Exactly. If the officer ignores that challenge and keeps digging, keeps arresting, keeps seizing evidence, they're violating Article 242.
But look closely at this specific element. There is a question brought before proper authority regarding his jurisdiction, which is not yet decided.
Right. The pending question.
This implies a limbo state. The question is not yet decided. I argue this is a weapon for the defense. Imagine an investigator is closing in on a massive corruption case. The target files a motion questioning jurisdiction, maybe on a technicality, maybe arguing the venue is wrong. Suddenly, the investigator is in the danger zone. If they take one more step, if they file one more paper or interview one more witness, while that question is pending, they are committing a crime under Article 242.
That is a very cynical reading. The element also requires that he has been lawfully required to refrain. It's not just the filing of the question that stops him, it's the lawful order to refrain because of the question. It implies a superior authority has said, hold on, let's figure this out.
But the not yet decided part is crucial. It punishes the officer for acting during uncertainty. In a fast-moving situation, say preserving evidence before it's destroyed, this hesitation can be fatal to justice. It favors the delayer. It favors the person who can afford a lawyer to throw up jurisdictional smokescreens. I challenge your jurisdiction becomes a magic spell to freeze the police.
It favors due process. I would much rather have an investigation paused and resumed than an investigation conducted by an officer who effectively had no right to be there. Imagine being arrested by a cop who is outside his jurisdiction and he knows it, but he keeps going because efficacy demands it. That is a police state. Article 242 prioritizes legitimacy over speed. It forces the state to stop and show its papers.
Legitimacy is important, but so is reality. And speaking of reality versus legitimacy, we have to talk about the ultimate legitimacy, competence, which brings us to Article 244, unlawful appointments.
Now, this is a section I assume we can agree on. It creates a meritocracy. It's the wall that stops the government from being filled with unqualified people.
Does it? Or does it create a scapegoat system?
The elements are straightforward. The offender is a public officer. They nominate or appoint a person. That person lacks legal qualification. And, this is key, the offender knows the nominee lacks qualification. If you appoint an unqualified crony, you are liable. That is a hard check on corruption.
You just highlighted the two escape hatches in your own description. First, knowledge. The offender must know the nominee lacks qualification. Do you know how hard that is to prove in court? The official just says, "Oh, I didn't know he didn't have a master's degree. I thought he did. I didn't check the transcripts myself." Plausible deniability is built right into the statute. It practically encourages officials to be willfully ignorant of their appointees' backgrounds. Don't tell me, just give me the paper to sign.
I disagree completely. Legal qualification is usually a matter of public record. You can't feign ignorance that someone isn't a lawyer if the position requires a lawyer. The law provides for qualifications required. It's objective. If the statute says you must be a CPA and you appoint a guy who isn't a CPA, I didn't know, is an incredibly weak defense. Courts generally assume public officers know the law and the requirements of the office they are filling.
Okay, maybe for highly technical roles. But the second escape hatch is even bigger. And this is where the Swiss cheese model really shines. The source material explicitly notes, recommending unqualified recommendee is not a crime.
Correct, because the recommender doesn't have the final say.
But that ignores how power actually works. In many cases, the appointing authority is a rubber stamp. The real power is the advisor, the party boss, the influential donor who recommends their idiot nephew for the job. Under Article 244, the person who actually pushes the unqualified candidate, the recommender, walks away scot-free. The official who signs a paper takes the fall.
As they should. The responsibility must rest with the person with the actual power to appoint. If you are a public officer and you are weak enough to sign off on an unqualified recommendation because a donor asked you to, that is your failure. You cannot outsource your liability to the person who gave you bad advice. Article 244 forces the appointing officer to be the gatekeeper. It says the buck stops with the signature.
It forces the appointing officer to be the fall guy. It allows the architects of corruption, the people pulling the strings and making the recommendations, to operate without fear of Article 244. A robust law would punish the conspiracy to appoint the unqualified, not just the final signature.
If I knowingly pressure you to appoint my unqualified friend, I should be liable too. I am the root cause of the unlawful appointment.
That would broaden the scope entirely too far. You'd be criminalizing advice. If I say, hey, I think John would be good for this job, and John turns out to be unqualified, should I go to jail?
If you knew he was unqualified and you used your influence, your political capital to push him, maybe you should. That's how nepotism actually survives. It survives in the recommendation phase. The law punishes the puppet, but completely ignores the puppeteer.
That's a compelling argument. But have you considered the chilling effect? If we criminalize recommendations, no one will suggest anyone for office. The law draws the line at the act of appointment. That is the moment the state's power is conferred. That is where the crime happens. The law focuses on the gate, not the path leading up to it.
And that is why the path is so crowded with corrupt intents. The gate is just a formality?
We're coming to the end of our time, and I think the distinction between our views is very clear today. I maintain that Articles 239 through 244 provide a necessary, structured separation. By clearly defining the offender, judge, executive, officer for each crime, the law prevents confusion. It safeguards the specific boundaries of each branch. It ensures that an executive acting as a legislator is treated with the severity that act deserves, as seen in Article 239. It prioritizes order and clear lanes of authority.
I come at it from a different way. I maintain that the specific exclusions, particularly the legislative officers not liable notes in Articles 240 and 243, reveal a code that is fighting the battles of the past. It assumes the executive is the only bully in the room. It fails to account for legislative overreach or the nuance of backroom recommendations in Article 244. It creates a system where if you have the right title, or if you stop just short of signing the paper, you can commit the same moral wrong as someone else, but face no charge at all.
It is a system of boxes, yes, but without those boxes, we have chaos. The law requires structure, even if that structure feels rigid.
But sometimes the boxes are what allow the chaos to hide in plain sight. If the definitions don't match the reality of power, then the law isn't a check, it's a blindfold.
A fascinating disagreement. Ultimately, whether these statutes effectively protect liberty or merely provide a roadmap for evasion is something for our listeners to ponder as they read the code themselves.
Indeed, don't just take our word for it. Read the notes. Look for the exclusions. Ask yourself who is missing from this list of criminals.
That's all for today. Join us next time on The Debate.